Welcome back to Eyewitness News this morning. Time now 8:49. We have Charlie O'Hara in the studio. That number is on your screen, 436-1212. If you have any legal questions you might want answered. Charlie, thanks for coming on our show as always. And I did have a question about a lot of stuff going on in the Kansas Supreme Court right now. Now, we're talking about the Carr brothers trial and how the initial death sentences have been overturned, but that's now back in court, potentially putting them back on death row, I guess you could call it. Why is that a complication? Why was the initial sentence of the death penalty overturned in the first place?
Well, we don't really do any of this now. We've changed, but at that time, they were tried in the same case. Both brothers were tried in one case. Today, we don't do that. We always try one in one case and then one in a separate case, so each of them have a fair trial. And the reason you do that is because one of the people, and I don't know that it's in this case, but one of the people may be much more culpable, more guilty, have done much more wrong than the other, and sometimes it spills over to both of them, and they're both convicted. And I think the Kansas Supreme Court, from the decision that I saw, had real problems with them being tried together. Now, they didn't overturn their convictions, most of them they didn't overturn, so they're still in prison for life. What they overturned was the death penalty, and obviously the Supreme Court always looks at a death penalty case very closely because, I mean, we're talking about killing people. I mean, the government's killing them, and they want to be sure they have everything right before they do that.
Absolutely. Now, that's a similar thing to what's going on in the Boston Marathon bomber, as the defense just rested in that case, saying that Johar Tsarnaev was not the mastermind behind it. I think that's what we're talking about for separating the trials.
Yes.
Now, we do have a caller on the line with a question, so caller, go ahead with your question for Charlie.
All right, am I on?
Yes, go ahead.
All right, hey, good morning, everybody. I had a non-person level 9 felony adjudicated and off paper for the past 10 years, and I was wondering, I know I can never carry concealed. I don't even want to carry, period. I just want to know if it's legal for me to have a firearm in my house. No, this didn't involve any domestic or anything like that, just habitual traffic. I just want to know if I protect myself, if I'm going to go to jail for being unlawful possession. Again, a level 9. Thank you.
All right, well, that's kind of a dicey situation, actually. And the law says that if you're convicted of a felony, you're not supposed to have a gun. However, there are times, after time passes, you can do that, but it also gets in a little bit of a conflict between state law and federal law. The federal law actually says you can never have a gun again, but usually the federal law gives into the state law. It's kind of a complex question, and I as an attorney, I guess being very cautious, think people ought to be real cautious about having firearms after they had a felony. They better check with all the authorities and make sure it's okay to do it before they do it. I mean, you can have a billy club, or you can have a baseball bat, or you can have a bow and arrow or something else other than a firearm.
Interesting. Yes, definitely make sure to check all legal channels on that one and be 100% sure that you can have a firearm in your house. Thanks so much, Charlie, for being on our show. We'll see you guys back here in just a moment.